Intangible assets are your best friends. They're often the most valuable asset a company possesses, even though you can't see it. So, on the other hand, they are your shield and sword in competition, because you can use that precious asset to hold competitors away from you or to achieve from them what you would like. So on the occasion of World Intellectual Property Day today, we believe it's a good idea to welcome you to our serious Brainchild lounge here with One IP International in Sydney. And I introduce myself first. I think my name is Olaf Kretschmer. I'm the principal of One IP International. We focus on protection and enforcement and defense of intellectual property rights of any kind, may it be trademark, patent, registered design, or plant breeders' rights, what there is in terms of intellectual property on a global level. So not just Australia, it is Australia, but first and foremost also European Union, the US, China, and what other market you may be interested in. Let's face it, sometimes you are the dog, sometimes you are the tree, and when you're the dog, thank goodness there are barristers who can help you achieving your success through enforcement of your intellectual property rights. Unfortunately though, you have to go to court, so the opponent would not just give it to you like that. But barristers, they're a very special kind. They know how to achieve results in the rough world of business. If you have your ducks in a row and you made your homework, and by that I mean you protect your intellectual property in the first place. So that brings me to the point that it's great to actually identify what your products are and what your brands are. If you know that, you can, on an initiative, go and register them so that you, in tough times, that you know what to rely on. Because the best barrister can't help you if you have no protection in place. Let's just assume you've done your homework and a competitor comes and would like to bite you off, or somewhat unfairly take some action on your business, and you would then try to find out what your rights are. Myself, having experienced legal issues with a competitor myself, and I had to go to court and involve barristers, it was a sort of onerous experience. I didn't quite like it, and I want to find out what is it like if you're facing litigation in Australia. Is it just that awful experience, or is it in a way, if you see it on a positive note, that you can do something about it and you don't have to stand for what your competitor's doing. So that's why we're welcoming Irina Hoskinson today. She is junior counsel, barrister in Sydney, and I'm really keen to find out what kind of tips she can give you today. Irina, welcome to the show.
Thank you very much. Thanks for inviting me. Glad to be here with you.
Great. So let me just start with you, coming from my very own experience. When we met each other the first time, subjectively, like from my state of mind, I was a real mess. It's like, oh my God, I've run into this. Do I have to sell the house? What is it? Where do I even start? And then I met you, and you did a great job to calm me down, take my mind at ease, put my mind at ease, and to give me some structure how to go through this. I think the most important thing for me was to not see this whole scenario unfolding all at once, but what you did is you broke it down into stages, like, okay, I need this first. then we look at the next stage, then we look at the next stage. From your perspective as a barrister, what would you say, what would you like to see in place when people come and see you for the first time?
Well, normally parties first approach their solicitors of choice. You can pick whichever solicitor you wish. Usually the solicitor then approaches the barrister, but I know that a lot of trademark attorneys brief barristers directly. That is because they've got unique expertise which combines some of the solicitor skills as well. So for this particular area of law, I would say I would expect either to be approached by the solicitor or by the trademark attorney first. Mm-hmm. What I would like to see is, obviously, if you are starting the action, I would like to see some evidence that the competitor infringed your rights. That evidence can be as simple as some printouts from the websites, or some short recordings from the advertising on radio or on TV, whatever it might be, photographs, whatever evidence the infringement. And it would be good if there is something written down, for example, a short timeline, mm-hmm. Starting when the mark was registered, and some evidence of that printout or whatever it might be, and then what happened next. So the best cross-examination technique or examination technique by the barrister is to ask, so what happened next? So it would be good, and for yourself as well, to write it down clearly in some kind of order, preferably in date order, but in the event order works as well. What occurred, and then having not necessarily a clear, but at least some idea as to what result you want to achieve, mm-hmm. right? So what happened, how it happened, and what is the result that you wish to get to. Mm-hmm. And that would be a good start.
And this is then where you create an affidavit with these things, or what do you do with this information?
Yes, so if you're starting, then if you're going to Federal Circuit Court, that's when you normally find yourself if it's a trademark infringement or patent infringement or design infringement. It's a Federal Circuit Court, Federal Court jurisdiction. There you will need to understand that there will be a statement of claim drafted for you, so that information that I've explained before would be used for that. Mm-hmm. And then to support that statement of claim or application, you'll later need to draft an affidavit. Affidavit is simply sworn evidence, which is what you say happened in your own words, but you swear that this is true and correct to the best of your knowledge and belief, and you have to swear that in front of a justice of the peace, solicitor or barrister. And that is your main weapon, so that's your evidence which goes to court, and then that evidence can be tested.
So that is the first stage, really, like after I approach you. Look, Arina, I'm a business owner, I have that problem, they sent me this nasty letter of demand, or they actually they served me with a statement of claim or an interlocutory injunction. What am I going to do? Or here are my trademark rights, this guy is infringing it, nothing is happening, we need to enforce this now. So the first thing is you ask a whole lot of information that lead ultimately to the drafting of the affidavit that this person then has to sign.
That's right. So if you're starting an action, there has to be a statement of claim or application filed, and if you are defending an action, then you need to file a response or a defense. Mind you, you need to file it quite fast, especially if you are on the receiving end of somebody taking you to court for trademark infringement, because the time starts running from the date you file. 3 years before, that's the time that you'd have to defend, say for example, for honest concurrent use, right? So don't dilly-dally. It's always better to be on the front foot, even though you probably wish that you could put your head in the sand and wish it will go away. It usually never does. So on the front foot, face your fears, and come to a specialist.
So, in terms of preparation, Irina, do you regularly engage consultants, say valuations or patent analysts, to build your case stronger in terms of, say, a business owner has received a letter of demand for patent infringement? Do you approach outside external consultants or subject matter experts to gather their opinion on the infringement?
Barrister usually kind of directs the action, or the solicitor and barrister direct the action, so they would recommend that the client obtains that. I mean, in practical terms, barrister or solicitor would already have a list of experts, or at least know where to go, but the choice is always the client's choice. Experts are expensive, and we have to remember that they are independent, so it may be that when you receive the report, the expert report, it might not favor your client's case. However, if that's the only report and you've advised the other side that the report's been ordered, then you'll have to serve that report on the other side. So this is a double-edged sword in terms of engaging an expert. So what I would say is not to rush to engage an independent expert first, but at some stage you need to make that decision. For example, if you need to defend trademark infringement, as we did in a recent case, what happened there is you needed to show as a defendant that you honestly concurrently used that mark. For that, you would need volume of sales, you would need numbers of sales, and you would need the regions of sales. Either the accountant of the client can collect that information, or you go to the field and get an expert to do that information, to collect information for you. That is the kind of expertise you definitely require. If you need any other specific expertise, that's usually on a case-by-case basis and discussed with your client.
But trust your barrister to guide you towards the requirement.
Yes, yes, of course. A case, especially a big case, would probably require those experts, and the barrister will advise you whether your case requires an expert. Sometimes the judge orders the expert. Yeah. So if it's a very narrow and very specific field where a person, even a legally qualified person, would not be expected to have an expertise in that, then the judge will be assisted by the report. In the lower jurisdictions, you're normally only allowed one report, which is a joint expert. You may ask for an individual parties expert. That has to be a special application made to the court, if the court has the rule that normally it's a joint expert. Or in the higher jurisdictions, parties just simply brief their own experts, and then what happens is what's called a hot tabbing. It's when both or 3 or 4 experts are in the witness box together and get examined and cross-examined together. Oh. And then that difference of opinion actually surfaces at that time, and some experts can change their view while they hear the other experts speak, and the judge can also obviously see what strength the experts possess. That's a completely separate topic. We can talk about hot tabbing. It's happens only in very large cases, because obviously 5 experts would be 5 times as expensive.
Very interesting point about the expense related to the litigation. I think it's the nightmare for everyone to receive a letter of demand, and first thing that comes into mind is costs. Yes. So in terms of costs, I think it requires a discussion as to everyone has an image that litigations run into millions. So what is your take on, or what in your experience, what range of expense are we looking at when we're entering the litigation?
Look, it sometimes is not, your hand is forced sometimes. If you are defending and the other side's already engaged a senior counsel, usually it is smart to level up, and therefore you'd have a senior and possibly junior counsel, and then yes, litigation is expensive, and that is what you read in newspapers or hear in the news how barristers are so expensive, $15,000 per day and things of that nature. But what you need to also look at is $15,000 a day for 3, 5, 10 days they are in court, as compared to solicitors who are running this matter for 3, 4, 5 years, charging $450, $500 per hour. Right, so you're not comparing apples and apples. However, that is for a large case or really hotly contested case. Usually, junior counsel will suffice, especially if around over 5, or possibly over 10 years expertise. Of course, the per hour rates also go up with that. That is not the only expense you have to think about. You have to think about experts' expenses, solicitors if you hire one, and administrative expenses like photocopy. Everyone and their dog needs a copy, and usually it's big folders, and the judge needs a folders or two. Sometimes a working folder and a clean folder, and that's not to be forgotten. Getting all the scary things out of the way. However, I wouldn't say that every single litigation requires you to break the bank or take a second mortgage on your house. Modern litigation is not just time costing. You can have an agreement as per task costing. For example, fixed fees. Fixed fees become more and more prevalent. I know solicitors who charge fixed fees nowadays, and in the competitive market, why wouldn't you? You'd also need to go into not just accepting what's given to you on a piece of paper. It is, after all, a contract. You can negotiate the terms of that contract. So the cost agreement is a contract with the barrister, contract with the solicitor, and that should be negotiated. And in the end of the day, unless you want to Brett Walker, who's the only one, you can find somebody else who is either more acceptable, not just by the fees. It shouldn't be the only factor. You have to click with your barrister. You need to have a team which you understand and which understands you, and that's the way you work the best, and that's not necessarily the most expensive one on the market.
From what I've seen in past cases, it's a good idea to involve a senior counsel that works with a junior counsel like you, so they team up to get you the best results possible in the shortest amount of time possible, whereas you want to cut corners cost-wise and have solicitors running around and spending 2 or 3 or 4 times more of the time charging. That's what you were just saying. And so you have the feeling you save money. In fact, it's going.
Yes, false economy. Get a good team and do not take your foot off the brake, so to speak. You need to be in control. If you want to control the outcome, it's one thing, but also the costs as well. Don't be afraid to have conversations. They're not very pleasant conversations, but don't be afraid to have them. Conversations with your legal team saying, look, this is where we're up to. And as you know, the law in New South Wales requires solicitors and barristers to give you updates if they think that the estimate will definitely be exceeded or will most likely be exceeded. Talk to your team, see how more efficient you can do those things. Rely on if your client can do some work, they should. It's in their own interest. It's their matter after all.
In terms of budget, what are we talking? 100,000s, or what would you say is the minimum budget you would need for litigation?
Well, look, unfortunately, it's really hard to put a figure on it. It depends on how complex the matter is and whether the matter will be hotly contested, or it's just simply putting something in through which is uncontested and registering something, or just contesting the decision of the registrar themselves, as opposed to also dealing with the opponent, the person who opposes you, for example, registering the trademark. Unfortunately, I would say though that you wouldn't get much change of at least $50,000 if it's a matter which has to be listed in court. So the pleadings have to be drafted, either defending or attacking. Then the affidavits have to be drafted, and that is without experts. So it's going to court, it's interlocutory proceedings, it's mediation, it's preparation, it's conferences with the client.
So, in terms of like, if say a small business owner approaches you and the cost of litigation you estimate is going to be $50,000 and they really can't afford it, do you encourage them to settle with the other party?
Of course, but again, this is not just about the costs. I know it's the most sexy topic, but it's not just about the cost. It's also about best solution. Can you live with concurrently using a trademark? Can you live with that? If your client doesn't want to or can't, then they have to face it. That's when I suppose the fees come into it. When you say no way can I let him or her use my mark, and then the actual numbers are shown. Okay, maybe I can.
Yes.
Right. So you need to test your client's strength of conviction as well. Mediation or other form of alternative dispute resolutions, again, is now by law dictated that the solicitors and barristers must advise the client. And why wouldn't they? It is cheaper, and also mediations or any other form of ADR is the medium where the parties control the outcome much more than when you put white pieces of paper and lots and lots of folders in front of a third party, which is a judge, and you just sit and hope. You sit and wait and hope that the decision falls over the fence your way.
Yeah.
While mediation, you can arrange really non-traditional and flexible ways of sorting things out, right? So from really strict, the same decision as the judge would have made, but the parties agree, right, by consent, to a completely flexibly crafted decisions or solutions which the court might not even be able to give you. So the outcomes that the mediation can achieve might not even be available from the court's limited arsenal, right? So mediation should be at the forefront of everyone's mind. But for that, good preparation is required. When we were talking about what to bring to the barrister, so I'm saying not to delay, but on the other hand, you need to collect some information, because if you don't have much information about the other side, you might settle for something less than you otherwise would have. You might panic, or the other side might not wish to settle because they don't know the strength of your case. So the best thing is obviously before the mediation to exchange some sort of evidence, those affidavits we were talking about. But sometimes it is probably better, especially if you're on the defending side, to mediate earlier. Then you limit your exposure to potential damages claimed.
That's our approach that we're taking towards advising clients, not like be the aggravated dog and biting everyone off, not being aggressive. We are more trying to prevent litigation from happening. If that makes sense.
That's right.
Sounds paradox, because we are lawyers, we should be interested to earn money with litigation, but don't worry, we earn our money anyway. It's much easier and much better, and the client is much better off preventing litigation from happening in the first place, which that's why we are providing strategic advice to have your IP rights, for instance, in row, and it's often enough to show a competitor, look, go away, I have done my homework, you can't do anything, or you better not putting this to the test because I am prepared. And coming from a German background, me being a solicitor and barrister in Germany, I must say my first experience with the Australian court system is how do Australians say, I was gobsmacked really to see that the costs can skyrocket, and this dual system with solicitor and barrister, which we don't know in civil code countries. And so it is actually a good idea to come to a barrister prepared, and by prepared I mean have protected all the IP rights, or whatever, like in a shareholder dispute, have some shareholder agreement, something that is more than just he said to me in an email or something, and then come to you and maybe involve someone doing valuation of an existing IP portfolio, whereas Pukit Popli is the valuation expert with One IP International, and he often advises our clients that are very surprised that they are what it's called intangible asset, because you can't touch it, you can't take it under your arm, that this thing that you can't see is actually worth that much.
Yes. And I think in terms of litigation, Irina rightly said that it is about what you're about to lose by going, or gain by going into litigation, and that's where the strategic advice is most important, to ascertain whether you're willing to risk it or not, and going forward with the litigation.
Yes. If you are the one who has the luxury of starting or not, if you are on the receiving end, as I said, your hand is forced. However, other alternative dispute resolution is still open to all the parties, and the courts are actively encouraging that. So even if you are on the receiving end of a letter, cease and desist or whatever it might be, don't panic. There are other options than full-blown litigation, which will take a fair share of your profits or of your hard-earned money.
What we often hear from clients is, oh my God, like now I'm going into litigation, what nasty moves can they make? People often do not focus on what can they achieve, what can they do. They are more worried about what can the other party do for me, to me, like in terms of, do they have a more experienced barrister that knows loopholes? I think it comes from all these TV series. Where they have the idea, or they can do something to me if my barrister does not know that very well. So from your experience, you're practicing as a barrister since 2016 in St. James Hall, is that right? So what have been the nastiest things that you came across? Like, do you remember something?
Well, actually it didn't happen to me, it happened to my colleague. She is convinced to this day that when they were in the conference in the other side's chambers, that the other side was in a different conference room in the same chambers, and they could hear the discussions through the phone, which is standing right in the middle here. She was convinced that the phone was actually on speaker without them knowing, because when they came in the same room, strangely the other side have anticipated every single move that they discussed in seemingly closed room with soundproof windows. So that was a really long move, normally, the arsenal of attack, even if you are yourself attacking, the arsenal of attack of the other side could be, for example, if you're the plaintiff, the person who starts the action, the other side can suggest interlocutory proceedings for security for costs. So they may say, well, you see how you started the litigation, but if you lose, do you have money to pay? And if the other side is successful on security for cost application, that means the plaintiff will have to be ready to put not only the cost that they will continue to pay their own solicitors and barristers, but also the cost of the other side up into the court's trust account and keep it there. So they have to be prepared to put a big chunk of money somewhere away without access to it until the end of litigation.
So thank you very much for these very valuable insights, Irina.
Thank you very much.
You're very welcome. We will be having you on the show later on another episode of that Brainchild Lounge series, when we're talking about shareholder disputes and how to settle, how to deal with it. Okay?
Looking forward to it.
Yes.
Thank you very much.
Thank you.
Bye.